Welcome back to the Jurist Prudence channel. Thank you for watching and for choosing us to be your law buddy. I urge you all to continue washing hands, keeping your distance, and to wear your marks when going to public spaces. COVID-19 might have not knocked into your neighborhood, but it's certainly real, spreadable and deadly. Likes, comments and shares are highly appreciated. If you're new, please subscribe and hit the notification button below. Today, let's talk about the protection of possession. Possession is the state of having, owning or controlling a thing. There are a number of remedies available for protection of possession of property. For the purpose of this video, we shall look at the one of mandement van spolie. This remedy is not necessarily aimed at protecting against infringement of property rights, but mere, unlawful interference with property relations, whether lawful or unlawful, by self-help and force. Self-help simply refers to when individuals take the law into their own hands. This remedy aims to protect the community against anarchy, chaos and to maintain public peace. The purpose of the remedy is to restore possession to persons who have been unlawfully dispossessed of their property, both movable and immovable. Courts grant it without considering the merits of the matter. There are two requirements which the applicant need to comply with, in order to be successful with the spoliation remedy. The applicant must prove peaceful and undisturbed possession of the property. Secondly, he or she must prove unlawful dispossession, or deprivation, by the spoliator. The control must have been exercised peacefully and undisturbed. It must be for a period long enough, and in a manner stable enough, to qualify any unlawful disturbance. Dispossession does not necessarily mean that the respondent must actually take control. Instead, destruction of the property can also constitute dispossession. For dispossession to constitute spoliation, it must be unlawful. When the action of the spoliator, respondent, is authorized by a law, or a court order, then it does not constitute spoliation. Unless, if it exceeds the limits of the authorization. There are nonetheless instances, where the remedy may still be denied regardless of the possessor satisfying the above-mentioned requirements. The following are defenses against the spoliation remedy. 1. Lack of the requisite control. 2. No dispossession of control. 3. Unreasonable delay in bringing the application. 4. Counter-spoliation, respondent's action amounting to lawful rather than unlawful self-help. 5. Special plea based on spoliation. It works exactly like the spoliation remedy, except that it is raised only in defense against another action, with regard to the same property. And lastly, impossibility of restoration. Impossibility implies that repossession of the spoliated property is not likely for some reason. In some instances, it might be impossible to return the thing because it does not exist anymore. Impossibility usually occurs where the property is either destroyed or damaged beyond repair. This defense has been raised in recent case law, particularly in cases involving unlawful occupation of buildings. These cases have claims from vulnerable and indigent occupiers. The occupiers applied for restoration of possession of the homes using spoliation. They had been evicted from their place of residence without a due process, and dispossession occurred, either totally or partially, by the removal of elements constituting shelter. The difference, however, was that the remedy was only successful in one case, despite the facts being similar, though not identical. Tswelopele non-profit organization v. City of Tshwane Metropolitan Municipality and others 2007. In this case, the original building materials had been utterly destroyed, and that nothing existed that could be restored, and the claimants, unlawful occupiers, had nothing left to return to. On that basis, the court denied the spoliation claim. Instead, the Supreme Court crafted a new constitutional remedy. The court therefore confirmed that spoliation is not available in instances where substitute materials are required to restore the lost possession. In the subsequent case, City of Tshwane Metropolitan Municipality v. the Mamelodi Hostel Residents Association 2011. The claim was successful, despite the roof having to be reconstructed with alternative components. The Supreme Court in this case simply applied the remedy without engaging a debate whether the spoliation remedy is available in instances where restoration of destroyed, or demolished goods is required. A conclusion could be drawn from this decision, that the mandement van spolie is available in instances where parts of property have been destroyed and reconstruction is required to place residents in the same position they were in, prior to the dispossession. The third case is Schubart Park Residents Association v. City of Tshwane Metropolitan Municipality 2013. In this case the Constitutional Court denied the spoliation and granted the Tswelopele constitutional remedy instead. The court recognized that if the mandement van spolie was not the appropriate remedy, and could not be developed to be the appropriate remedy, the occupiers would be without a remedy in a case where there was clearly an infringement of Section 26(3) rights. In this regard, the court followed the approach adopted in Tswelopele. Thank you for watching. Please subscribe if you haven't, like and share the link with your friends. Take care. We are forever your law buddy, until the jury do us apart.